vote is a little bit.
The Honourable Acting Chief Justice, members of the Judiciary, including, of course, the Magistracy, the Solicitor General, Permanent Secretaries, the heads of various organizations, including the various independent commissions, fellow legal practitioners, ladies and gentlemen, and also, of course, our law-invited guests, including our New Zealand High Commissioner. Ladies and gentlemen, as tradition, we normally just do a quick summary of the 2 days events and perhaps some of the key salient issues that we need to sort of eke out that would not only be relevant for you as individual lawyers, in particular those in the private sector and also those in the public sector, but also perhaps to provide or ignite some form of interest in some of the cutting edges or cutting areas of the law that's going to be coming up this year, in the months to come, or even in the next couple of years. But before I do that, I'd like to again just formally acknowledge the, given that it's the Attorney General's conference, passing away of the former Attorney General, Aiyaz Sayed-Khaiyum. He was the Attorney General of Fiji for approximately a year. He passed away in New Zealand, we understand. I'd just like to acknowledge that. Ladies and gentlemen, there's a number of topics we talked about. I do not want to go into detail regarding those topics, but perhaps to talk about some of the issues that will come up in whether cases that you're doing or in respect of public interest. I think one of the issues regarding the contractual performance is that, you know, the definition of act of God, whether pandemic falls within that. We have seen amendments to the law, in particular the Employment Relations Act, where under the particular provision, there's a duty of the employer to actually continue to provide work if there is an employment contract. That duty, however, does not necessarily have to be fulfilled if certain conditions exist. One of them, of course, being an act of God. And that was specifically to provide certainty to include, amended to include a pandemic, because it was not definitively put in the law itself. But as Peter C. has highlighted, that does not necessarily extend to other contracts that may exist, private contracts, contracts between a borrower and a lender with banks, etc. So I think that distinction is important for all of us to know and understand. And things like, of course, what is material adverse change. These are critically, important concepts to understand. As government, what we are specifically concerned about, and as you know that we made various announcements, is in the space where the ability of one of the parties to negotiate on a level playing field does not exist. And normally that is in the area of banks and borrowers. People, for example, with home mortgages, people with personal home loans, those who may actually have hire purchase agreements. The individuals are generally contracting with a much larger party that has got far more bigger resources, access to well-paid lawyers than they themselves individually do. So as a government, we are concerned it's a public interest issue. And once COVID-19 came to place, we very quickly had meetings with a number of these providers, asking for example, their cooperation, collaboration to defer principal payments, in some cases defer interest payments, and what could be done to help people negotiate during this particular period of time. And as has been the case, there was an agreement, not in writing, but a general agreement, a gentleman's agreement, that this would continue till the end of December, which is coming to end in a few weeks' time. We have, over the past week or so, have had meetings, including the hire purchase companies and the financial institutions, including the governor. And, just to let you know, we intend to present a bill in Parliament next week to give certainty to these borrowers of money, those people who have mortgages, so that they themselves, are able to, in a way, have some sort of psychological certainty. I can give you numerous examples. I met a gentleman in Lambasa some weeks back, and he was working for a particular company in Lambasa. His employment had come to an end because of COVID-19. He was about 53 years old. He's of course been earning, a very modest sum of salary throughout his lifetime. So in 3 or 2 years' time, when he goes to withdraw his FNPF, he's not going to have, hundreds of thousands of dollars or millions of dollars in his FNPF. It's a very modest sum. But he had a personal loan, or he has a personal loan, about $2,700. The bank understood his situation and said, okay, you don't have to make any repayments. But in the meantime, the interest is accumulating. So his loan now, payable, as of a few weeks ago, is about $3,300 or $3,400. It's jumped from $2,700. He's now back at work, but purely on commission. In the past 3 months, he's only collected $500 in commission. Now, he's a single person, he looks after his elderly parents, but he's concerned that if the interest keeps on accumulating, it may reach $5,000 or $6,000. And when he goes to withdraw the sum from the FNPF, should he wish to do the lump sum payment, most of it probably go towards paying off this loan. So what safety network does he have at the point of retirement? So these are the types of parties that we are actually concerned about. And we've had, like I said, a series of meetings, and we hope to bring a new bill to Parliament. We're still negotiating with the banks and the hire purchase companies who actually are a lot more amenable to some of the propositions we are proposing. We are not trying to undermine the financial integrity of our financial institutions. Of course, FNPF has to play a pivotal role in respect of that. So we are particularly also concerned about home mortgages, because the argument being, what's the point of not allowing them to access the FNPF funds now if they, in the meantime, are going to lose the roof over their head? So if they lose the roof over their head, they may have only $50,000 upon point of collection at pension, or $30,000, but they're homeless. So these are the issues that we have to grapple with, whilst at the same time giving the latitude to the financial institutions to be able to carry on with their business, being able to be compliant with the APRA rules, making sure there's enough liquidity in the market. But what is really interesting, and I know we had the lady from Tower Insurance, areas of such as life insurance and medical insurance. So, these are not very easy issues. I had somebody who just emailed me about a week ago saying that we had a group scheme insurance of life insurance with a particular insurance company. And because they come from a hotel industry, their members can no longer do the insurance premiums payment on a monthly basis. So can you ask the insurance companies to put our insurance contract in abeyance until we get our jobs? Otherwise, they lose all the money they've actually contributed as premium, and the insurance company goes off and they go off without any insurance or life insurance. The question, of course, is you can put their premium payments on hold and the contract in abeyance, but what if the person dies in the meantime? And the same thing with medical insurance. You may say, okay, we won't do the medical insurance because you no longer have a job, but you still expect coverage. So just because there's no premiums doesn't mean there's no ill health. Just because there's no premium does not mean there's no death. So these are some of the issues, of course, that companies themselves actually have to grapple with because it affects the customer base. So that's something that I just wanted to sort of talk about, but also be on the lookout for this, the laws that we hope to have finalized and put before Parliament next week, under Standing Order 51, of course, if there is an emergency. Cutting emission through international trade. Again, I think it's again a very important area, and one of the things that I've said continuously And to be frank, I think many practitioners in the private sector, or in the private practice, are losing out potentially in a lot of work because they are simply not giving enough time to understandings of the new and very rapid areas of development in law. For example, carbon trading. And as you heard from the speakers, carbon trading actually will mean there's going to be property rights. I know some of the lawyers in this room do a lot of conveyancing. And you have not actually thought about carbon trading as, conveyancing. Because the moment you actually are able to register under it's called the Register of Carbon Sequestration Property Rights under the Climate Change Bill, please look at that. You actually have got clients in the making. Once it's put in the register, then it gets actually registered under the instrument of title, through the Register of Titles. You can actually transfer that property right. So, again, it's also at the same time recognized as a personal property for the purpose of the Personal Property and Securities Act. This is a normal property right. How many have thought about that? How many have actually thought about representing land-owning units or even individuals who may actually have a lease, state lease, crown lease, or people who may have freehold land, who may actually decide to not cut down their forest or in fact get into replanting. And there's actually a price mechanism to it. You have to think along those lines, understand there's actually a market for it. Somebody told me, one of the lawyers from the AG's office said to me that one of the staff of the law firms over here said, we come to the AG's conference so we know what's coming up so we can go and actually develop that particular practice in our law firm. I'm glad they're doing that, good on them. I urge others to do that too. Because suddenly, as we've found in the past, one or two law firms suddenly become experts in one particular area of the law and everybody does not participate in that space. They're able to market themselves. They've got a nice little page on their web page to say we are experts in this area. So please look at these areas. I mean, one of the things about carbon trading though, of course, if we want to do it well, is that you need very strong verifiable data. You need transparency in it. As I highlighted yesterday, the Butoni wind farm. Apparently there was some carbon trading went in, the money's disappeared, nobody knew how it was priced at, how it was priced, and who actually got the money. Under the Climate Change Bill, you'll actually have a legal framework, you have a national register, and then people can use that register to be able to trade. And it can completely change the economic landscape of our country in respect of that. And the other area that I also want to talk about, a lot of people when you think about carbon trading, they actually only think about what we call terrestrial carbon trading, which is forests up in the hills somewhere. But there's also blue carbon, mangroves, seagrasses. And in fact, blue carbon or the blue economy has got a much higher level sequestration rate. In other words, you all know that trees absorb carbon dioxide, but the stuff in the sea, the mangroves, actually are able to suck in more carbon than what the trees on the hill can do. Higher level sequestration rate. And the figures are something phenomenal. I don't remember it offhand. Something like 3-4 times more. So you have a mangrove forest, it can suck in more carbon than the forest that's actually up in the hill. So there's numerous opportunities. And as we mentioned that we're talking to the Brits in this respect in getting some blue bonds issued. And there'll be quite a few other things that we're doing in respect to the bond market. And again, there's a lot of opportunities for the private sector, lawyers in private practice for that. But I think with the blue bonds, we hope to get some better pricing around it. As I mentioned yesterday, that we've got green bonds is now listed on the London Stock Exchange. The interest rates that we have to pay is not exactly, fantastic. We pay 6.3% for a 13-year term bond and 4% for a 5-year term loan. But please remember, very soon in Fiji, you'll be able to do secondary trading in the bond market. Normally in Fiji, people buy the bond, they get a physical paper, certificate, and they put it in the drawer and wait till the end of the term of that particular bond. We will now very soon through the Reserve Bank of Fiji have secondary trading. You get electronic versions of the certificates. So if I buy a bond today, it's a 13-year bond, I can actually go and trade. How many of the lawyers in this room know about secondary bond trading? Please don't let it be the exclusivity of only one or two firms. All of you should get into space. Not all of you, if you have an interest, but I'm saying that there is opportunity there. Indeed, you'll invariably find people who want advice from you. You need to be able to get into that space. We are going to, hopefully in the next few days, sign an MOU with the Carbon Market Institute Limited of Australia to again build our own internal potential and capacity within the Ministry of Economy. And you know, the only reason why the Climate Change Division rests with the Ministry of Economy is because we need to mainstream climate change. See, if we want to have net zero emissions by 2050, every single project we'll do will need to have a net zero emission. So whether you're representing a client who may be doing a particular contract for government to build a school or a hospital or a bridge or whatever it is, you'll have to be able to understand these concepts because that's what the contracts will now actually include. Rising tide, I know some people have said to me, it was a very technical session, in a geodetic and all these kind of terms and that came up, and I thought it was probably a bit unusual for a lawyers' gathering. But again, I think some of the policy documents does have an impact. For example, the Constitution, the climate change policy, the Suva Declaration, Climate Change Bill, Climate Relocation of Communities Trust Fund Act, Planned Relocation Guidelines, Displacement Guideline. For us, what's really critically important, I get onto the sort of the human rights side of it, it's quite clear. But just to sort of refer you to the Constitution itself, even in our preamble, if you read our preamble, page 1, one amongst the many declarations, declaring that our commitment to justice, national sovereignty and security, social and economic well-being, and safeguarding our environment. Now, similarly, and again, the jurisprudence in the area of developing, our human rights, the Bill of Rights, I think is very, very small or lacking. Every person in Section 40 has every person the right to a clean and healthy environment, which includes the right to the natural world, which is actually very wide, this definition, natural world, protected for the benefit of present and future generations through legislative and other measures. These are enforceable rights against the state. These are enforceable rights against the state. How many lawyers have actually looked at it from that perspective? So I just wanted to flag that with you. But one matter that is critically important as far as the rising sea levels is concerned is this, our EEZ. You see, your EEZ is measured, and this is where your land ends, is 200 nautical miles out from where your land ends. So if your land is getting eroded, washed away, then you're moving further back. So then your EEZ is actually becoming smaller. This is the big debate. It's the big debate about countries like Tuvalu and Kiribati and other countries where the highest point above sea level is only 12 feet. So their economic zones are getting even smaller, and which is actually their lifeline. They make lots, the only major income they have is giving out fishing licenses. So if their EEZ is going to become smaller, the ability to give licenses to those areas of sea that are currently within the EEZ will diminish. So the income will diminish. So I think, the 200 nautical miles has the archipelagic waters, the territorial seas, which is about 12 nautical miles from the shoreline, and the contiguous zone, which is 25 nautical miles from the shoreline. So it's a real issue for us. It impacts on livelihood, our ability to give licenses, ability where our people can go and fish, ability to give fishing licenses to foreign vessels. All of that actually, it becomes problematic for us. I think the other point also is, which is some useful statistics that Tima just highlighted, that 27% of Fijians live within 1 kilometer of the coastline. 27% of Fijians. And 76% of Fijians live within 5 kilometers of coastline. 76% of us live within 5 kilometers of the coastline. So it's only 24% that actually live beyond 5 kilometers. So somebody, I think Ada had asked a question about, what happens to the urban cities and the towns and etc. Of course, the bulk of the population is there. So this is why, we need to have a holistic approach to climate change in terms of development of our policies and in terms of our town planning, what level of infrastructure needs to go into those spaces. And the other point, of course, that I very quickly want to reiterate is the issue of insurance. Whilst generally insurance is sought against climatic events like hurricanes, etc., but also flooding is a major issue. Nandi and Ba towns, most insurance companies don't give insurance coverage to us ordinary individual households. They only give it to the big companies. And again, the access is actually quite high. So those are the kind of issues we need to be able to understand the impact it's going to have. So the level of investment and infrastructure investment needs to be targeted in those areas. So we are working currently, for example, with the Japanese government, with ADB. There's a $400 million program that we have in terms of ring fencing Nandi from flooding, both from inland flooding and of course from, rising waves, etc. The designs and trademarks, I think, again, is very interesting and in fact quite complex. And a lot of people, I think, don't realize this. But I don't know how many of you actually know, but our trademark, currently the Trademarks Act, goes back to the Trademarks Act of 1933. Our Patents Act, current Patents Act is relevant to Fiji, goes back to 1879. Our Designs Act goes to what we call the UK Designs Protection Act, 1937. Now you'll be glad to know that these three bills are actually being tabled in Parliament next week for the committee to actually review. But one of the reasons also that we are putting in place these bills is because Parliament has agreed, and we've already now in the process of ratification of the Paris Convention, which is the protection of industrial property, and also what we call the Madrid system, which is the system of international registration of trademarks. Under the Madrid system, you actually have the Madrid Agreement and the protocol itself. What it does, one of the things it does do, is that if you register in one country, your trademark, then it automatically gets registered in all the other member states of that particular convention. So at the moment, there's 120 member countries to this particular convention. So if you develop a trademark, a unique Fijian trademark, you register it in Fiji and you're part of this convention, then 119 countries will automatically recognize your trademark. You don't have to individually go to those countries to register your trademarks in the respective jurisdictions. So that's the beauty about it. Of course, when we had the convention before the committee, a couple of law firms made representations to the committee to say, don't do this because, it will affect our business. Because, one or two law firms in Fiji specialize, and again, those of you who are not doing it, you're missing out on it or have been missing out on it, they specialize in registration of trademarks. So you'll see many ads come out in the papers, X company X is registering the trademark. So they say we lose out on business. But what they are not looking at is that the ability of now Fijian businesses to be able to register their trademark. So it's the mentality of us always being the recipient, as opposed to us being actually starting a particular trademark ourselves. It makes it easy for us. When we're actually registering our particular mahogany brand, we literally spend, and SG knows about this, hundreds of thousands of dollars going to individual countries to register our trademark. So in this way now, under the new system, once the bill is put in place, and we've now ratified the convention, all our trademarks will get automatically registered everywhere. As a matter of interest, ladies and gentlemen, and I think, again, Aiyaz had raised the issue about, kava, etc., and the word Fiji. Two well-known Fijian products that all of you know as Fiji Water and Pure Fiji weren't registered in Fiji. They were initially registered, the first one, in USA. Then it was brought to Fiji, and the then Attorney-General allowed it to be registered or trademarked in Fiji. The other one, Pure Fiji, was registered in UK. Then it was brought to Fiji. As you know now that we don't allow for anyone to use the word Fiji, even in company names, because that is our trademark. It's the nation's trademark, every citizen's trademark. And the word Fiji actually, without mentioning other countries' names, is actually conjures up very positive images. So the point being, in fact, some companies that have registered said we own the word Fiji. And that is a battle that we actually do have. So for a small country like ours, if somebody is, for example, exporting ginger, and we've got very good ginger, we've now got very good turmeric, and as a matter of interest, in the past few months when Fiji Airways has only been taking freight flights to LA, 80 to 85% of the cargo has been agricultural products or produce. Bulk of it has been yangona, which is our obvious product to USA. The next highest one now is turmeric or hardi. Everybody's now health conscious, COVID-19. Turmeric has got now these superfood qualities that people have just discovered. Of course, people on the Indian subcontinent discovered that, a few hundred years ago, maybe 1,000 years ago. But the point being that if you're going to have multiple suppliers of ginger, say to USA market or turmeric, should one company have the word Fiji turmeric or Fiji ginger in it? No. So our thinking as government is that we hold the trademark. We can say Fiji ginger. And then if these people over here want to export ginger to USA or anywhere else, Commerce and Trade certifies that they've met the standards, they can then carry that logo, Fiji ginger. XYZ company sells Fiji ginger. But that name should rest with the Fijian people. So you see, these are the mechanisms that need to be built in. So this is why I brought about these laws, because we are able to then protect our own citizens and protect our own trademark and bring back revenue to us, as opposed to a national good, a national commodity being owned by one company or two. Now, the trademarks and patents and designs bill, I think also there's sometimes a bit of confusion, and I just wanted to very quickly expand under the new bill as far as the trademark is concerned. And please go and make your submissions to the committee, because we'll be tabling this in Parliament, goes off to the parliamentary committee. Is another new trademarks bill is now going to become a lot broader. So under the current meaning of trademark under the current act, it's only limited to goods and does not allow for service signs. For example, denoting a particular service. So this is how it is being expanded. Similarly, the grant of patent gives the patent owner the exclusive right to make, use, and sell a patent invention. It's very interesting. And this way of cross-cutting of what we call traditional knowledge too. There's a very famous case. Some of you know the neem tree. The neem tree is known to have fantastic qualities. People get all sorts of chicken pox or whatever it is. They put neem leaves and you lie on it. People drink it, they make tea out of it. Farmers now use it as a natural pesticide. Now, an American company went and actually patented the neem tree product, because they said, whilst it's an indigenous intellectual property, not however registered, they said we've actually done a particular processing of this neem tree or the leaf, and they've come up with a product which has got its unique way of producing the final product, and they patented it. So many NGOs, Indian NGOs actually took them to various international arbitration. To be frank, I remember reading about all of this, and I did not know actually happened in the end. But this is the type of situation actually that can arise. Which brings me up to a couple of things about the designs, and also in respect of for example traditional knowledge, regarding, I know my wife mixes certain leaves, etc., pounds it when somebody's got a flu or earache or whatever it is, or wanting to lose weight or diarrhea, whatever the case is. Now these are very old, passed down knowledge from centuries. Now indigenous knowledge in Fiji is not written. It's actually oral. So the documentary evidence is a lot harder to trail or to track. Now, once you get into the space, for example, and we've got a bill actually that's coming up, as we mentioned in Parliament, which is going to be called the Traditional Knowledge and Traditional Cultural Expression Bill. Now, and the Ministry of Itaukei Affairs, for example, is doing what we call a cultural mapping exercise. Because the moment you assign a dollar value to something, people can start claiming it to be their own. I think somebody mentioned yesterday or today that they come from a particular province, and this is and we know that, for example, masi making in Laos is very different, and unique traditional mat making is different. Now, what if one province or one area claims this is ours, but somebody else may claim the same thing? The other question that does arise is that there's a traditional way of making masi, but the design may be unique to the person who actually knows the technique, but they have their own design. So who actually owns that IP? Who actually owns that design? Australian Aborigines have a particular way that they do their painting. They use a particular leaf to do dots, and they join dots essentially to have those paintings. They use a particular dye, natural dye from the trees. Now that's fine, you're using the technique that's been handed down, but if that painting is actually unique to yours, nobody else has ever done that, even in your own Matangali or tribe or landowning unit, but it's your own, and you then decide to sell it for consideration, what's going to happen then? The point is, it's not always very clear-cut. And the point is, when there is also within that particular indigenous grouping people claiming to have the first right or the first intellectual property right over that particular aspect of the design or that intellectual property. Very critical, you have to really understand this. In the same way, for example, and I know Ada had raised the issue about, Margareta Matamosi. She's no longer with us, God bless her soul. But when she was actually commissioned by Fiji Airways to design their logos for their livery, what people call the tail. Pursuant to a commissioning agreement. They actually had an agreement. I remember meeting her myself. And I had asked, you okay with this? Sign the agreement, you happy with the pricing? Yes. That was fine, and then Fiji Airways went and actually registered that particular livery design with the Fiji Intellectual Property Office. There were some other designs they wanted to register, there were objections, and they weren't registered. Now subsequently, and I think after all the, I think a lot of misinformation on social media, etc., Ms. Matamosi took Fiji Airways to court to say that she wanted more compensation. Not contesting the design, but wanting more compensation. And that because she had done it, it still belonged to her, but they wanted more compensation also. Unfortunately, she passed away, but her estate took over the matter, pursued the matter. And then the parties actually came to an agreement where there's an out-of-court settlement pursuant to terms of settlement. So those designs that were actually being objected to, because they're too common and used by other people, that was objected to, and that was never registered with the FIPO. I think the other issue, again, for those lawyers who have an interest in this area, please get up to speed with the new bills that are coming up. There are 3 bills that will be tabled in Parliament next week. They'll go to the committee, of course, and the committee then will call for public submissions. And I think it's critically important to get a lot of public input into that area. Last but not least, I wanted to and talk about the rights and freedoms with COVID-19, the restrictions on that. I don't have that much to say on it because I think you had some very good speakers, including the Acting Chief Justice and the Director of Human Rights Commission and Dr. James Fong also. The one thing that I wanted to talk about is that normally when we talk about rights, or for example rights being infringed, people generally tend to talk about civil and political rights only. they tend to forget the socio-economic rights. In fact, in our constitution, we have a vast array of socio-economic rights. And suddenly these rights can actually become competing rights among them in itself. So, I've got it here somewhere, the actual section. Section 32 of the Constitution. Everybody has a right to economic participation. Now, if you are going to not restrict your rights, your movement rights, etc., and allow, for example, COVID-19 to take hold of the country, couldn't you also argue that the state is in breach of the right to other people's economic participation because you not control their disease, and therefore subsequently all these other people who would not have lost their jobs if you had controlled it, now have lost their jobs? It's a very strong argument. The state must ensure that people have, within its reasonable means, the right to economic participation. So I think in Fiji, whenever we talk about rights, people tend to only focus on civil and political rights. They're not focusing on socio-economic rights, which we have actually now ratified the International Convention on. The right to health. All of you have a right to health. Now, if because we're saying, we're not going to do this lockdown, and we, lockdown or maybe a curfew, and the result of you not doing the curfew means that a lot more other people in Fiji will get sick. Isn't that a competing right? Aren't you actually disenfranchising them of that right to health? So again, the reason why I'm highlighting this because, we need to be a bit more expansive in the way that we look at rights. And I know many lawyers in Fiji have not really attuned to socioeconomic rights as such. People always talk about right to having a lawyer, right to free speech, etc., and even that, there's not a very nuanced approach to that. I think, but that's critically important. I mean, one other right that we are actually quite keen on is that, and it's not necessarily a national application, but our right to a vaccine, should a vaccine develop. These are some of the things we're having this incredibly late night virtual meetings at 2 a.m. in the morning with people in Washington, UN, in London, various other places, that Fiji believes that any vaccine that comes out should not be treated as a commoditized product. It should be seen as a social good. Can you imagine if, because we are small, Pacific Island countries are small, and because we don't have the volume, and therefore pharmaceutical companies won't be interested in you, that you get pushed down to the pecking order, and all the other big countries start getting vaccinated, and everybody starts traveling with each other, and the Brits and the Europeans and the Aussies, everybody's happy. We won't have the slice of the economic pie. If the French territories through France are able to get vaccines and we don't, guess where all the tourists will go? As Dr. Fong talked about the juxtaposition of, doing well economically and not doing well health-wise, or doing both. So that's something that we actually have to ensure. And Australia has made a public commitment. The Australian Prime Minister has made an announcement that they will use best efforts to ensure that the Pacific Island countries actually go up the ladder quickly. So that is, from our argument perspective, that's one of the rights that we want as global citizens. I think the other point that a lot of people don't have an appreciation of, and whilst we've sort of made a number of public statements on this, is how in some countries you can argue and say that the use of digital technology in terms of controlling COVID-19 has insidiously moved into their private space. Classic case in point is the Care Fiji app. A lot of the countries that actually have got a similar system to Care Fiji app, or the objective being contact tracing, knows where you are when you have the app on, has in fact your address details, and some of them even can access your data. Care Fiji app does not do that at all. all Care Fiji app records is that the moment if I have my app on, the Honorable Chief Justice is within 1.5, 2 meters of me, and I'm there with him for more than 15 minutes, his number will get registered to my phone, and my number will get registered to his phone. So assuming we are here, and then God forbid, you're assuming that I have COVID-19, I have test positive, they'll need to know who I have been in contact with in the past, I think, 28 days. His number will be registered on my phone. The moment I get told I have a Care Fiji app, they say, can we access your phone in respect of that? They'll send me a PIN number. I actually have to agree to that. I put in the PIN. Then on the Ministry of Health's dashboard, all the numbers that have been in close proximity to me for more than 15 minutes, within 2 meters, for the past 28 days will pop up on the screen. That's all. Not where we met, what we talked about, does not access my phone's data, nothing, only the numbers. They won't even know his name. They'll simply dial the number, excuse me, sir, madam, you have been in close contact with a person who's tested positive for COVID-19. Where are you? Can you please come quickly to the nearest health center, wherever they tell you to come to? That's it. But in other countries, we're getting this, where people have a lot more information. They can access your data, etc. Most of you have WhatsApp. Most of you have Viber. You have given them more information about yourself than to anybody else. They probably know your mother's name. I get messages in my Viber message saying, so-and-so who's on your Viber group is birthday today. People give a lot more information to get access to apps, those kind of apps. Google knows more about you than we do, frankly. Of course, some countries have now decided to bring in what they call the anklets for monitoring your movement. Because now, of course, quarantining is becoming very expensive for a lot of the countries. They're running out of space. So some countries are looking at home quarantining you. So they put these anklets on you, or proposing to put anklets on you. If you step out of that boundary, everybody comes around. So they know you within the space. They probably know when you go to the loo. The other point that I wanted to highlight, which has always been my plug, and that is access to finance. In all of this is critically important. We are literally in Fiji now have already spent millions of dollars quarantining our own citizens who are coming back from overseas. You don't pay a single cent if you're a Fijian citizen. All that cost, your hotel cost, your accommodation cost, your meal cost, is borne by the Fijian government. It kind of ties in well with climate change. The sort of calls we've been making on the international stage is that because we are at the coalface of climate change and because of the excesses of the industrialized countries, we are the coalface of climate change and bearing the brunt. So therefore, shouldn't there be some form of accessibility to us to concessional financing? Putting us in the vulnerability category. And we have indeed made some progress on that, but we need more progress on that front. It was very interesting before I round off. When we talked about the Care Fiji app, a couple of business consultations we had, I had people asking me things like, I have 2 phones. Can I switch one on and the other one off for Care Fiji app? Because I don't want people to know where I was. Will they be able to know who I met with in the hotel room? Seriously, and these are educated people that asked that question. So please be rest assured we won't know who you met with, where you met them with, and how many of them met them all together. Ladies and gentlemen, I'd like to take this opportunity to once again thank you for your participation. I'd like to also thank, and not forgetting all those people in the rooms outside this conference room, including those in Suva. We had, as of Thursday morning, only 5 people interested to come to Suva House because we had some people who wanted to come along and they had missed out. I know a number of you actually are not staying in this hotel because they cannot accommodate you here because of the various restrictions and because it was overbooked. But by Thursday afternoon, as I said to Mary, because we had decided, well, Mary had decided that if we don't have any more than 10 people, we won't have Super Bowl up and running. So I said to Mary, please just reach out to them personally and say to those 5 people that if you don't get more than 10, we won't be able to give you access to this conference. By the afternoon, I think we had 22, Mary? 22 by Thursday afternoon. So thank you all of you in Super Bowl House, and please put your hands together for them, because it's not very easy to be part of a conference when you're actually physically not there, in particular if it's in the same country. Ladies and gentlemen, we also as a tradition have a call up all the individuals who have put enormous levels of time, energy and effort and indeed dedication in ensuring that we have a very successful Attorney General's Conference. We have our own trust fund. It's not funded through government budgetary allocation. They make a little bit of money through your attendance, so we can actually continue to have these conferences year in, year out. And we always have this tradition of thanking them publicly. And I'd like you to please put your hands together at the end of it all when we call them all up. But we also normally get somebody to give others gifts, and we are very glad that Mrs. Kerr has Philo, as we all call her favoritely, that has agreed to give others gifts. Please welcome her and please come on stage. Thank you. So I'll call out the names first. We have from the top, we have Deepak Singh, please. Tunrao, Wangalala. IT guys. Vim Suluyeti, Balakiwai. Vimal Ram. Rina Silatolu. Rina asked me not to call out anybody else's name until she does the catwalk. And then Aiyaz Sayed-Khaiyum. Sefa. Nonotimate. Nimitesh Kumar. Abhishek Singh. Upashna Kiran. Sakyasi Bulavo, Rakesh Bhagwan, Prabhas Prasad, Patel Lendua, Lavinia Wangani Burutukula, Prashant Chandra, Prakash Rao, Nidhani Saurara, Olivia Vatmbua, Felipe, but Felipe is not here, Selvin Sharma. Shelvin is a lone ranger from the west. Amalia Galbao. Ronil Deo. Ronald Singh. And the matriarch, Una Modesuva. Please put your hands together, ladies and gentlemen. These are the support staff, and as you know that we've been dealing with them. I'm hoping they've been really tough with you on you signing up and attending the conference. One more time, please put your hands together for them before I close it. I'd like to now call the actual conference committee. This is normally made up of the lawyers within the chambers. Sanisha Kant. Oh, Sanish, sorry, not Sanisha. Sorry, Sanish. There's a difference between an A, can change things, right? Sanish Khan, Priscilla Singh. Priscilla. Manisha Ali. Valerie Narayan. Glennis Andrews. David Solvalu. Ofa Solimailangi Lemaki. You have to get used to the Lemaki bit. It's a new addition to Ofa's name. Why don't you guys just sort of come over there? Don't stand behind me. No, just, you can occupy the third row too, some of you. Please. Ofa. And our chairperson, last but not least, our chairperson, Mary Lee. Mary. Ladies and gentlemen, please put your hands together for all of them.